and launch that. If you all can participate, you should be seeing that on your screen. Let us know if you are a community-based advocate, a systems-based advocate, if you're part of the criminal justice system, if you're a medical staff, or if you are other. Please do specify that in the chat box so that I can call that out so that we know who's on the call with us. So some of the other that is coming in is we have a therapist, we have a high school social worker, a prevention specialist, we have a CPS caseworker, residential program provider, and it looks like currently we have about 18% community-based advocates, 24% criminal justice system employees, and that keeps bouncing around a little bit. I'll leave this open for a few more seconds, so make sure you get your vote in. That way we know and our presenter knows who is on the call so that it informs some of the information that's going to be talked about today. So I'm going to go ahead and close that poll. Thank you all for participating in that. And I'm going to go ahead and share the results of that. Most of you voted. Thank you for that. So we have 29% community-based advocates, 5% systems-based advocates. We have 19% criminal justice system employees, and we don't have any medical staff. And then we have all the other folks who I mentioned earlier. So we have another one came in, a DA victim specialist. Thank you all so much for being here and for sharing who you are with us. At this point, I would like to go ahead and turn it over to our presenter. Again, like I mentioned, we have Teresa Stroud, who is the the Senior Program Associate at the National Prison Rape Elimination Act Resource Center. So Teresa, thank you for being here. We're happy to have you, and I'll go ahead and turn it over to you.
Okay, thank you, Maria, and I'm really happy to be here today with everybody. Let me go ahead and advance this slide. Let's see. There we go. Took me a second to get reoriented here. But my name, like Maria said, is Teresa Stroud. Really pleased to be here with you today. This is a very important topic. I've spent the majority of my career working with juveniles and at-risk youth. I worked for 5 years as a child care licensing specialist here in Texas. I'm located in the Austin area, and monitoring child care facilities and registered family homes for compliance with state minimum standards. I was additionally responsible for investigations of abuse, neglect, and exploitation and child deaths in those facilities. I later went on to work for the the Texas Juvenile Justice Department as a youth rights specialist, managing the youth grievance system internally and investigating allegations of abuse, neglect, and exploitation in those state-operated juvenile correctional facilities. Most recently, I worked for TJJD as their Senior Director of State Programs and Facilities. So I was with them for about 20 years altogether, and was responsible in my most recent position for all of their operations and treatment programs for the agency's halfway houses and state-operated secure facilities. So we had about 1,100 kids in residential care at the time. So one of the significant duties that I had was ensuring that all of those facilities were PREA compliant, and the agency PREA coordinator worked for me. So I've been with the PREA Resource Center now for about 5 months from leaving that other organization, and but I've contracted with them previously and done quite a few trainings related to juvenile justice and PREA. So looking forward to talking with you guys today. I wanted to just talk a little bit about the PREA Resource Center, my employer. So you noticed on one of those slides, I'm sure that at the top it talked about Impact Justice. And Impact Justice is actually the name of the company that I work for. And the PREA Resource Center is a division of that nonprofit. Impact Justice is a national innovation and research center that advances new ideas and solutions for justice reform. This includes a focus on reducing the number of youth and adults entangled in the criminal justice system, improving conditions and outcomes for currently incarcerated people, and providing opportunities for formerly incarcerated people to rejoin communities. The PREA Resource Center, which we frequently refer to as the PRC, is primarily focused on eliminating sexual abuse by increasing each of the facility's capacity to prevent, detect, and monitor their responses to these incidents and services to victims and their families. The PRC is responsible for the training process for any individuals who are seeking certification through the Department of Justice as PREA auditors. PRC staff conduct the application and screening process, conduct the courses, and field training programs for rigorous on-site training audits for auditor trainees. And after they go through that coursework and the field training program, they can become certified as probationary auditors. And then the division I work in is the Audit Quality and Integrity Division. We're responsible for monitoring the work of probationary auditors. And once someone's certified as a probationary auditor, they have to submit 2 reports to the AQI division for review and feedback. And the point there is to help new auditors comply with all the requirements of the auditor handbook, which are promulgated by the Department of Justice and the PREA Management Office. The division does additional work, quality work with auditors who may need improvement in their auditing process and reports. So that just gives you a little idea of what we're doing. I'll talk a little bit about juvenile justice system structure and process. Each state, this particular slide is from the Office of Juvenile Justice Delinquency Prevention website, because it does provide a high-level overview of what a case looks like for a young person in the criminal justice system in the U.S. Now, most of them are going to look like this. There can be nuances from state to state, of course, that could affect or impact how a juvenile is processed. And each state gets to determine a variety of things that have to do with how juveniles are processed, including the minimum age that they would be served in their juvenile justice system, minimum age that they could be transferred into the adult system. We're going to touch on some of those things today. But primarily, it all begins with a contact with law enforcement. And that law enforcement in many times comes through school, an activity that happens at school that results in police. Generally, so many schools now have police on site, so that maybe an on-site police officer, or it could be the local police department being called in. And then those kids are assessed once they've been charged with breaking or violating a law. They're assessed by the prosecution's office. The local district attorney usually has a juvenile division if the town is big enough. In some cases where they're more rural, than someone in that office handles, all levels of prosecution. But a decision's made as to whether or not that student's going to be held in detention pending the outcome of their case, or whether they can go home with a responsible family member, guardian, parent until their case is disposed of. And so we'll talk about some of that formal processing. But at the time that that decision is made, they do get a court date for a final decision and the charge against them. And they're either held in detention with some level of due process at that point, or they're passed on into allowed to go home and return to court for their final hearing. And in the criminal justice system for juveniles, it's not referred to as a conviction if they're found to have committed a crime. It's referred to as an adjudication, and we'll talk about that in a little bit more detail as we move forward. But after adjudication, you can see that there's several things that can happen that have to do with either probation or some other non-residential disposition, a residential placement, or some type of aftercare, and aftercare, I'm sorry, from the residential placement before they're released finally. And I just wanted to touch on the fact that the placement of a state's juvenile justice division or agency depends on the state legislature. Some states have independent state juvenile justice agencies. Other states opt to place their juvenile justice agencies within a human services, child welfare, or adult corrections agency as a subdivision. In Colorado, the Youth Services and Justice Program is a division of the Colorado Department of Human Services. And Colorado's Youth Services Division serves children from the ages of 12 to 20 years old. There's current best practices in juvenile justice across the nation that result in most communities investing in local community diversion programs to work towards keeping juveniles at home or in a suitable community placement outside detention or secure placements wherever possible. But when those efforts fail or a juvenile commits a law violation that makes him or her a clear risk to public safety, that's when they would be held in detention or committed to longer-term secure placements. So, talking about those options in the adjudication of a minor. Children can be placed under a court supervision as a result of having engaged in delinquent behavior. And the process for that varies from state to state. But the basic finding is this. The court has a hearing, and either on admission by the child or after hearing evidence in the hearing about the acts that they are charged with, the court moves to and says that they believe that the child has committed the act that they were charged with. So that is how adjudication takes place. So where it would be a conviction in an adult criminal court. And then following that adjudication, the court moves to disposition, which does resemble sentencing in an adult court. And at that time, the court determines the sanctions and treatments. Once an adjudicated juvenile, once they're adjudicated, they're subject to out-of-home placement. But that is not always the resolution to an adjudication. Placements determined based on their needs and the best interests of the respondent, as well as the need for the protection of the community. The process of adjudication should not appear on a juvenile's adult record except in limited circumstances. Those vary, again, from state to state. All states have some sort of procedures that allow juveniles to petition to either seal or expunge their records in certain cases. There are at least 15 states in the United States that have laws that automatically seal or expunge juvenile records in certain circumstances. Those include, I won't name all of them, but Texas is one of them, South Carolina, New Hampshire, Nevada, California. Colorado does not have an automatic record sealing law. An individual with a record for juvenile crimes in Colorado can ask the court to expunge or seal his or her criminal record. And that expungement does mean that their, pardon me, record will be as if it never existed. The public will not be able to see the record. After the expungement, a person can then legally claim that he or she was never arrested, charged, adjudicated, convicted, or sentenced for a crime. If that case was ever transferred between different counties in Colorado, the motion to expunge should be filed in each county to make sure all records are sealed so that there's not an open record in one of the other counties. There are some crimes that are ineligible for expungement or some issues. So a person's not eligible for expungement if the individual is adjudicated for a felony offense involving unlawful sexual behavior, if they're determined to be a violent juvenile offender, if they committed a homicide or related offense, or an offense which occurs pursuant to Title 42 of the Colorado Revised Statutes. Generally, a person is eligible for expungement immediately after a case is closed as the result of a dismissed case, after the completion of certain programs, 1 year after certain conditions occur, or 3 years after an unconditional release from a juvenile sentence. I will tell you that in doing research on Colorado law relevant to this, it states repeatedly, you know, that there are some fees associated with it, and it's very complex, and legal counsel, would be advised in determining how a student or child is going to have their record expunged. I want to talk to you a little bit about case process and key decisions. We talked about this briefly, but when children are waiting a disposition in their case, they could be held in detention. And the reason that they could be held is if the judge believes it to be in the best interest of the community or the child, the best interest of the respondent or victim, protection of the community, or if he's concerned the child may not return to court. But continuing to hold a child in a detention facility requires significant due process and routine hearings. And I did note that Colorado requires a hearing before a magistrate and a decision about continued detention within 48 hours of placement. The detention model's advanced quite a bit in recent years, and rising detention populations in the 90s and projections for increases led legislators in many states to determine that there would be a significant operational burden and expense if placements in facilities continued to be the single solution to provide necessary supervision to troubled kids. And there was a key belief that there were juveniles housed in a secure detention facility who could be safely supervised in the community given the appropriate level of services. So those spurred the creation of alternatives to detention programs, which are now primary in the assessment of a juvenile's unique circumstances. Any opportunity to keep a child in the community and in their home where possible, even research supports that. The lower level offense that a child has committed, if they're placed in placements, generally the worse they will get. The more, so the lower the offense, the less times they've had interactions with the juvenile justice system, it's in their best interest to keep them in the community and divert as much as possible from the residential setting. So in the key decisions, Colorado says there's 4 factors that affect the ability to try a juvenile as an adult. That includes their age, the type of offense they're charged with, the extent of their past delinquency, and whether the district attorney wants to invoke the district court's original jurisdiction or transfer a pending juvenile court to the district court. And the decision to transfer them is based on what you call statutory exclusion, the judicial waiver, age restrictions, and concurrent jurisdiction. Youth committed to the Division of Youth Services are subject to several sentencing options, including non-mandatory sentences where youth can go before the Juvenile Parole Board once they complete treatment. There are mandatory sentences available, and those are a minimum of 1 year. And then juveniles who commit aggravated crimes can be sentenced up to 7 years. Generally, the likelihood that a DA would file criminal charges against a juvenile as an adult increases with the juvenile's age, the severity of the offense, and their past history. Under Colorado law, the youngest age at which a child can be tried is 12 if they're alleged to have committed a Class 1 or 2 felony or a crime of violence, and the juvenile court transfers the case to district court. The purpose in providing this information is to emphasize the fact that young children may be handled as adults in a system that's designed for adults. Think about 12-year-olds that you know in your own life and their capacity for rational thinking, particularly rational thinking under pressure. Many of the kids who are involved in the juvenile justice system have unique challenges, and in some cases they have serious mental health issues, emotional disturbances, or educational disabilities. These deficits make it difficult, if not impossible, for these young people to act in their own best interest or advocate for themselves. While they have a right to an attorney, in many cases, they are court appointed and handling literally hundreds of cases, making it difficult to provide the level of attention and care each of these cases deserve to protect the young person's civil rights. There is significant research available that demonstrates the human brain continues to develop into a young person's 20s, and the rational part of a teen's brain won't be fully developed until age 25. Adults think with their prefrontal cortex. That's the rational part of the brain which responds to situations with good judgment and awareness of long-term consequences. In a teen's brain, the connections between the emotional part of the brain and the decision-making center are still developing. Just wanted to show you here, this is the minimum age that a child in these states could have their jurisdiction changed and transferred to adult court. So at 10 years old in the states of Kansas and Vermont, a child charged with certain crimes can be processed as an adult. In Colorado, Missouri, and Montana, that minimum age is 12. In Illinois, Mississippi, New Hampshire, New York, North Carolina, Wyoming, it's 13. You see several states that have it at 14, including my state, Texas, and then New Mexico's out there on its own. All the other states that are listed don't have a minimum transfer age and treat these cases on a case-by-case basis. These are really just the minimum age at which a juvenile in each of these states could be transferred to an adult court for certain crimes. Most juvenile systems in the U.S. are designed to serve youth as young as 10 or 12 up to the age approved by their legislature. For instance, Colorado's age limits are 12 to 20. In my state, youth as young as 10 can be committed to the juvenile system, but you still have to be 14 to be considered to be tried as an adult. And the oldest that kids are kept in Texas are 19 years of age. So they can't turn 19 in our facilities. They have to be released the day before their 19th birthday or transferred into adult jurisdiction. I want to just talk a little bit about the detention versus secure placements. Detention, the key here is pre-adjudication. They haven't had final resolution in their case. The average length of stay for kids in detention awaiting that type of decision is 22 days. These statistics were taken from the Office of Juvenile Justice and Delinquency Prevention. The states are still required, or the local counties are required to provide educational services, general and emergency medical care, and access to attorneys and guardians. A youth could be charged with a crime and under certain circumstances be released from detention within the same day if a judge finds it appropriate to do so. Many youth who commit low-level or nonviolent offense such as property crimes or vandalism or first-time offenses are provided services in the community and remain at home. Alternatives to detention programs can provide rich services, including family counseling, parenting education, systemic therapies, such as FST or MST, increased supervision and monitoring to help keep kids at home with their families. But once a decision is made and the youth is adjudicated, they may still remain in the community under the supervision of the local probation department and can participate in a variety of programs, including special educational programs, substance abuse treatment, and other therapies. Youth who are successful may never be subjected to an out-of-home placement if they're successful in the community. Youth who are committed to out-of-home placements will normally be placed according to their treatment needs, with consideration given to the type of crime committed, number of previous referrals, and again, specific educational needs as well as their criminogenic risk. So in the long-term placement side, post-adjudication, their average lengths of stay vary, but across all states, we're around 4 months in 2015. Educational services are required. They have to be provided. All their physical, mental, dental health services, immunizations, routine sick call, and access to attorneys, guardians, family, and other advocates must be provided. Just wanted to share with you some of the demographics of youth who are involved in the justice system. And these particular demographics were pulled from the youth.gov site about justice-involved youth. Youth of color are overrepresented in the juvenile justice system, both in detention and long-term placement. Minority youth are more likely to be detained and committed than non-Hispanic whites. LGBTQ youth are overrepresented in the juvenile justice system and the criminal justice system nationwide. Nearly half of all the youth in juvenile justice facilities are assessed at an academic achievement level that's below the grade equivalent for their age. For instance, on average in Texas, we received youth who were at least 2 grades behind in reading and math. Justice-involved youth are identified with a need for special education services at a rate that's 3 to 7 times the rate of youth outside the system. That's a pretty significant statistic. More than 48% of the kids in the juvenile justice system in the state of Texas require special education services. And I believe that across states, that number's rather solid. Many justice-involved youth have a history of truancy and grade retention, and a large number of them have a history of trauma, emotional, and behavioral problems. You see there 65 to 70% have a diagnosable mental health disorder, and nearly 30% experience severe mental health disorders. Many experience co-occurring disorders. So these demographics tell a story of a youth who may have been underserved in the community, particularly in the area of mental health treatment and those with a history of trauma. This just tells you some of the things that youth who are detained or incarcerated may be subjected to. Physical and sexual violence, additional trauma, a risk of suicide and death. I did look up some information about how PREA allegations are. So these types of incidents should result in investigations inside these facilities. Some of them should result in investigations external to the facilities. The Colorado DHS has an FAQ page for frequently asked questions for their youth services. And specific to PREA, it talks about how PREA allegations are investigated. Employees, volunteers, contractors, and interns with the Division of Youth Services are mandatory reporters, and therefore they're obligated by law to abide by the mandatory reporting laws and any DYS policy. Whenever an alleged incident of sexual misconduct has occurred within a facility, the incident will be reported to the DHS division, the Colorado Division of Health Services, and the appropriate local law enforcement agency. Additionally, an internal investigation is conducted to determine the appropriate administrative or personnel actions to be taken. The internal investigation will not interfere with or duplicate an investigation being conducted by the County Department of Human Services or local law enforcement agency. Many PREA allegations result in multiple investigations. Many correctional facilities refer to internal investigations by non-licensed investigators as administrative investigations. So they investigate any parts of the allegation which might not be a violation of the law. But any part of an allegation that would definitely result in a law violation if found true are investigated by criminal investigators, certified officers, or certified peace officers. So that may be, depending on the location, that they're referred out to the local sheriff's department, the local police department. Some agencies have an office of inspector general who conducts criminal allegations within their agency, but that office of inspector general actually reports directly to the governor's office and is not supervised by anyone in the agency at the agency level. Many adult correctional facilities have the Office of Inspector General associated with their correctional agencies. that's report, whose duties are all located within those correctional facilities, but they report to the office of the governor. The internal investigations have to do with administrative or personnel actions that need to be taken. And many times those might be held until the criminal allegations are investigated and cleared, so that they're not interfering with any sort of criminal allegations that are going on or investigations. They don't want to influence the answers. They don't want to be doing multiple interviews of juveniles who've been subjected to any kind of physical and sexual violence, because that can, as you guys, many of you well know, can taint the interview and the evidence that you're getting. It's best to allow the criminal allegations to proceed before any other types of investigations take place. I'd really recommend visiting the Youth Services and Justice page on the DHS website, as each facility is listed along with the judicial districts that they serve. And clicking on that information about a facility can get you to links which provides you information about visitation, and links on how to contact information for key administrators at the facility. Colorado also has a Child Protection Ombudsman. That's an independent, neutral state agency charged with reviewing complaints concerning any publicly funded services that are provided for the safety, permanency, and well-being of children in your state. So that would be an outside agency to which any allegations could be reported. I do want to take a moment now to see if there are any questions about what we've discussed so far that anyone might have.
Yeah, Teresa, we do have one question that came in. This person says, I'm a sexual assault victim advocate that works exclusively with people with intellectual disabilities. I have been trying to negotiate to provide services inside the local jail. They don't feel as if they need this to be a specialized service, but according to your statistics, it seems they do. Do you have any advice for me to get access?
Well, that's a great question. I would approach this in one of two ways. One way might be reaching out to the local disability rights advocates in your area to talk, because those folks will know very solid statistics on the demographics of people in that local jail that are processed through there routinely. And they will be aware of some specific cases where they did not feel that someone was provided the services that they needed because of their intellectual disabilities. And they might be someone who have influence with some of the jail administration to have them include you. Because while they might not have a large population at any given time of prisoners with intellectual disabilities, because I think in the local jail, people feel like, well, they're going to process through pretty quickly. They're not going to be here long term. Then they will, they don't see as much of a need for it. But people, as you probably know, since you're an advocate in this area, people with intellectual disabilities are some of the most vulnerable individuals out there, and absolutely need a higher level of advocacy to be sure that their rights are protected and that they receive all the services that they should receive. You could try appealing through the local jail's administration, talking to someone who is in maybe their mental health division to see if that's one way to go. But I think the disability rights folks may have some good advice. You just want to be judicious in how you handle it, because sometimes when you go with groups like disability rights or other advocacy groups, people might be reticent to share information with you because they might feel like the services were forced upon them, instead of understanding the benefit for their inmates who suffer with these disabilities.
Thank you. That was the only question that has come in so far, but just as a reminder, as you have questions, feel free to type that into the question box and we'll get that answered for you.
Okay. So when we talk about, I'm not going to read all this to you, I promise. I'm sure some people are saying, thank goodness, right now. I just want to put it on the screen and talk about it a little bit. There are several standards related to the care of people in custody. And some of you may know some of this, but I'm going to back up just a little bit. There are standards that are specific to adult prisons and jails. There are standards that are specific to juvenile facilities, and then standards specific to what we call community confinement centers, where people are generally transitioning from a higher level of restriction and have some autonomy in the community for work and other services. And then standards specific for lockups, very short-term jail-type facilities. So I'm showing you some of the standards that are specific to juveniles. And there's actually resources on the PREA Resource Center website, that's difficult to say, that allow you to kind of compare the standards to see the differences, if that's something that interests you. But what's most important about these standards is that they relate to many of you, the type of work that you're doing. And so I wanted to make sure that I brought up some specific points about the evidence protocol and forensic medical examination. This particular standard actually has multiple provisions. We refer to, when it's listed with A, the letters A, B, C, how we have them listed there. It looks like I actually made a mistake on this one. It's always great to find it when you're actually doing the presentation. So in this particular standard, there are some differences specific to juveniles, but it talks about in provision B that the fact that a protocol, any evidence protocol that is used for investigating these allegations of sexual abuse needs to be uniform, and that it should be adapted or otherwise based on the U.S. Department of Justice's Office on Violence Against Women publication, that National Protocol for Sexual Assault Medical Forensic Examinations for Adults and Adolescents. While it was developed in 2011, it's been updated in 2013. And that particular document is a fantastic document. It provides detailed guidelines for evidence preservation and collection for criminal justice and healthcare practitioners to follow in the immediate aftermath of a sexual assault. So some of the things that it focuses on are how to plan for and develop an immediate response protocol for incidents of sexual abuse and confinement, what training core responders need to be able to do to fulfill their responsibilities. So that applies when a report of sexual abuse is made for medical and mental health staff, investigators, and victim advocates. It describes how to locate victim advocates, how to orient advocates to the correctional environment and discuss topics like confidentiality and security, how to work with advocates to determine the range of supported services they'll be able to provide and how they will provide them. Otherwise, like, are they going to be by phone, at the hospital, or at the facility? It works on considerations for developing a memorandum of understanding with advocacy programs. And the standards really push having an MOU between these two facilities, because it makes it clear what each one of the agencies can and cannot do in terms of providing services. Just keeps everything very clear. This particular publication that we've been discussing talks about how to locate sane or safe programs and facilitate exam site readiness for serving incarcerated victims, how to negotiate operational security procedures if the victim's transported to a hospital for an exam. It talks about the importance of using independent forensic examiners and understanding that a forensic exam addresses the full spectrum of sexual abuse, not only attempted and/or completed sexual penetration. And it contains information that victims should receive following an incident of sexual abuse. these are some other provisions of this specific standard 115.321. It talks about evidence protocol and forensic medical examinations. So similarly, when you identify a rape crisis center willing to serve victims from correctional facilities, it can be challenging. In some cases, rape crisis centers may operate on very limited budgets and may lack capacity to expand service provision to incarcerated people. And then sometimes advocates from rape crisis centers may need some training or assistance with gaining comfort in working with incarcerated victims. We really strongly encourage you, if you have not ever been able to, ask for a facility tour. Particularly in a juvenile facility, most juvenile facilities are very open to providing facility tours or have routine tours set up for individuals. They want people to learn more about the services they're providing. They recruit volunteers frequently. They want people to work with and mentor kids. Some of the kids don't have family that visit, and they need someone who is showing a routine and dedicated interest in them, because having that in lieu of having a family member visiting can really improve outcomes for the young person. So tours are really critical. I will say that, I know that you were asked, one of our participants was asking about an adult facility. Many of them will have some tours available too. I'm sure that that there are some who do not do that, do not do it routinely because of what they would say are public safety interests. But if one is available and they'd be willing to give it to you and provide you a tour of their services, I just strongly encourage you to do it, because it helps you understand the setting, particularly if any services that you're going to be providing are going to be provided by phone and not actually on site at the facility. It just helps you understand what the culture is like there, what the victim is dealing with in terms of what services are provided. And then some of the final provisions of this standard have to do with investigating the allegations of sexual abuse. The agency being audited for PREA compliance can't control the actions, obviously, of external agencies in reference to how they conduct investigations, like sheriffs or police departments, but they do have a responsibility to show they attempted to gain compliance and actually requested that that external entity comply with the provisions of standard 115.321. If they can demonstrate that they did make the request, then they're considered to be in compliance. Standard 115.353 talks about the resident's access to outside support services and legal representation. The legal representation is specific to juveniles in this case, but the facility needs to provide residents with access to outside victim advocates so that they can have emotional support services related to sexual abuse. And it's required that the agency make every effort to have that information posted. If they have a youth handbook, it should be in there. There should be information with addresses and numbers posted in your telephones so that juveniles have an opportunity to get that information without having to ask for it. It's just openly available in day areas or in the educational areas. And it's really strongly encouraged that that information be available in more than one location so that juveniles could get to it without having to talk to a staff on the floor to get the information. When PREA auditors are conducting audits in facilities, they conduct many, many interviews. They do random staff interviews and random inmate interviews. And then there's interviews that they conduct that are targeted to specific people. So some of the people that a PREA auditor will want to talk to are any juveniles who've reported a history of sexual abuse or who have previously reported allegations of sexual abuse within the facility. Those are specific kids who would be targeted for interviews. Kids with intellectual disabilities are targeted, and one of the reasons there is to make sure that they understand all of the PREA education materials that are supposed to be presented to help them understand and know their rights for sexual safety, that they're being presented in a way that multiple people can understand. There has to be a way for them to access services if they are blind or visually impaired, if they're hearing impaired. There has to be an availability of interpreters for language barriers as well. And so in talking to the residents and reviewing files and other information provided by staff, it helps the auditor come to a good understanding of whether or not the facility's really in compliance with all of those standards. Because if a student or a juvenile can't understand the information that's been provided, in other words, you hand that juvenile a bunch of information in print and he doesn't know how to read, then none of the information's gone over. It's of no value to him whatsoever. And so the standards specifically address that sort of thing. And the purposes of having outside support services, quite specifically, are because if you're locked away in a facility, you're away from home, you only get access to phones when you're allowed, and maybe for only a certain number of calls in a designated time period. Most juvenile facilities are not set up so that a kid can go use the phone whenever they want to talk to whoever they want, nor is any other correctional facility. But most facilities are required, well, all facilities are required to provide an opportunity to use the phone at no cost to the juvenile to make a report of a sexual abuse or sexual harassment allegation outside of that facility. There has to be a third party that they can report to. And many of them have set it up to where the third party is the agency that handles child welfare abuse complaints in their state. Some of them have set it up to do some other sort of third party. For instance, in the states of New Mexico and Oregon, they serve as each other's third party. There's a division in the Department of Corrections in New Mexico whose job it is to take third party reports from any prisoners in the state of Oregon who would like to report sexual abuse or harassment, and then vice versa. So there's lots of unusual and different ways that can be set up, but it's very important that they have a third party that they can report to, and that they're very well informed about getting access, and that they understand any limits to the confidentiality between those places. Many correctional facilities do record phone calls, not as often in a juvenile setting as they do in an adult setting. But if those phone calls are recorded, the juvenile has to be warned that they are recorded, so that they know exactly the limits of whatever confidentiality. Obviously, a victim generally would feel safer and more comfortable talking with somebody who has no official involvement with the facility where the alleged abuse occurred. And that's the purpose of the standard, to provide that kind of access to outside departments. So I hit on a few things there about that standard, but I want to make sure that if there's something that I missed, that when you get a chance, you're able to ask a question about that. I've got a list here for you of a few resources that I think are important. And so I wanted to make sure that you got access to these. I listed for you some of the places where I got some of my demographics and the information that I shared with you in these slides. Of course, one of the ones that is of much importance here is the PREA Resource Center where I work. That particular website serves not only to provide information about the standards, but it provides a wealth of information on resource topics. It serves as a library of documents, programs, and resources where people can go, whether they're working on compliance with PREA within their agency, whether they just want to learn more about PREA, or how PREA PREA impacts these different advocacy organizations in the areas where correctional facilities exist. So that is, you can just go in there and search for just about anything. When you're looking at a particular standard, if you have interest in that, there's a tab there for you to click on frequently asked questions, where people have over the years had questions about the interpretation of a standard. And if there's been several, when you click on a certain standard number or a topic, it will bring up all the related questions to help provide some context for how we determine compliance in those areas. So it's just a really great website. Just Detention International, is an advocacy group, and Just Detention International, for many of the corrections agencies, has postings up, and this is a place that auditors will check with to see if they've had reports from inmates or residents about any type of sexual abuse or sexual harassment allegations. So an auditor, when they're preparing to go do an audit at a facility, before they even go, there's lots of information they're going to be reviewing, but they should call Just Detention International in the area to see what reports they have on that facility. They should call the local hospital where the agency is saying that they're getting their SANE or SAFE services from, and talk to the person in charge of those services and ask about their memorandum of understanding or agreement and how often services are being provided. And they should be talking to any advocacy groups who've agreed to provide outside emotional support or counseling. And not to get any details, of course, regarding those services, but to make sure that services are being accessed. So, when you're asking a facility prior to an audit, you ask them how many allegations of sexual assault and sexual harassment they've had involving their inmates or residents for the previous 12 months. If they tell you they've had 30, say it's a facility with 1,000 prisoners, and they say they've had 30 allegations of sexual abuse and harassment, they have to be able to break those down to you, where they inmate on inmate, staff on inmate, and break them down by harassment and abuse allegations, as well as providing the findings and the outcomes, whether or not any of them were referred for criminal investigation, and what were the findings of those criminal investigations, and whether or not the findings were presented to the prisoners or residents. We refer to juveniles as residents. So it's a lot of information that they have to have. So if you call JDI and JDI says, we've had 70 calls from that facility, and they can usually tell you it's 70 calls from, it's always good to know, were those 70 independent people who called you, or did you have any one or two people call you multiple times? So they can usually tell you, I've had 70 calls from 58 individuals altogether, but you've only had 30 allegations of abuse and neglect. That's something that auditor needs to look into to see why there's a discrepancy. If they can figure that out, they need to be able to know. And if they can't figure it out, they need to still report in their report that there was a discrepancy regarding the number of reports that JDI is receiving versus what the facility is reporting. So another good resource is the PREA Standards in Focus at the PREA Resource Center. That's a program that's ongoing, and it just provides a higher level of detail about the requirements of a standard, what compliance looks like, and resources that a facility might use to help them be in compliance with those particular standards. There are about 17 of the standards that have received one of these fuller documents, the Standards in Focus, and the Resource Center continues to work on getting other ones done, and eventually all of the standards will have a Standard in Focus document prepared for it. This is a really important piece of information as well. The Youth Services and Justice Division in the state of Colorado is located within the Colorado Department of Human Services. And every state agency, federal agency, or private corporation that provides residential services to people in corrections has to post information. They have to collect data. They have to post an annual report with the data that shows how many allegations they've had and what the findings of those were. And then they have to also post publicly the most recent PREA report for all of their facilities. So when you go to this particular site with DHS, it has links to the facilities that are managed by DYS, and it will show you the most recent, when you go to that specific facility, there's a place to look at all their statistics and their annual reports for the past 3 or 4 years, and then a place to look up the actual PREA report, the final report from the auditor about each of those specific facilities. I was looking earlier, and the Colorado Department of Youth Services has 10 facilities that are state-owned and operated that are juvenile, and 5 of them, when you go onto that site, you can see which jurisdictions they serve and which judicial districts they serve. 5 of those facilities house kids both who are being held in detention and receiving some long-term services, so they can mix their populations there. 2 of those facilities, or 3 of them, do detention only, and then 2 only hold long-term kids who've already been adjudicated. But the agency, the population in Colorado is such that the agency also has an additional 3 facilities that it owns, but they're privately operated by the rite of passage contractor, that are state-owned facilities, privately operated, and then another 23 contracts for various size facilities throughout the state. And every one of the facilities they contract with for care of kids in a residential setting must also be PREA compliant. So it doesn't matter if they're run by the state, they're owned by the state and operated by a private provider, or if they're completely run by a private provider, nonprofit, for-profit, doesn't matter, they have to be PREA compliant. So all of them are subject to that. And then I wanted to provide you too with the information for the Colorado Child Protection Ombudsman with their phone number and then a link to their website, because if you had a concern about a child in detention or in a juvenile placement, they would be the people to call if you don't get good resolution at the local level or the agency level. So I wanted to include all of that. And I want to see now if we have some additional questions.
Yeah, so a few questions have come in from folks. The first one is, hi, thanks for taking the time to answer questions. Under PREA, facilities classify assault claims, as you mentioned, as either unfounded, unsubstantiated, or substantiated. In your experience, do investigators tend to accurately categorize victims' claims? And if not, how could facilities improve?
There are, the more I have worked with PREA, the more facilities I go into, I do have a level of concern about how well a victim's claims are being categorized. The investigation reports are open to a PREA auditor, so they get to see the entire report and any evidence that was collected for any reports of allegations of sexual abuse or sexual assault for those previous 12 months. And if they see as an auditor that those investigations really aren't conducted thoroughly, they have any level of concern about how an investigator came to the finding of unfounded or unsubstantiated, those are defined in the PREA standards. And when it comes to administrative investigations, the standard of the burden of proof is a preponderance of evidence. And it's very simply stated, is it more likely or not that that occurred? There's actually a 51% standard. So if it's more likely than not that that thing occurred, then the preponderance of evidence states that that would be confirmed. They're not as an administrative investigation, they're not required to have the burden of proof of a criminal, court of law beyond a reasonable doubt. That's not the same standard at all. And so it's interesting. One of the things the auditor must do is say whether or not they feel, based on all the evidence that they looked at, whether or not those investigations are being completed the way that they should be. And the standard that deals with investigations most specifically is standard 115.71 in the adult facilities. It's 115.371 in the juvenile facilities. It's a very complex standard that talks about the training that should be received. And those investigators should be receiving training that's very specific to sexual abuse and sexual harassment in a confinement setting, because there's much different dynamics that a prisoner or resident is going to experience than they would out in the community when they're free to go home. And a lot of different dynamics in terms of, they're being held at that facility. All the services they receive are subject to those staff. And they're required to monitor anyone who makes an allegation, including staff, for retaliation and the possibility of retaliation for up to as much as 180 days following an allegation. So I went a little further with that answer than I really probably needed to. But yes, it concerns me. And whenever they're audited, the auditor should be addressing how well those are conducted, whether the investigators have all the training that they should. And the auditor has a right to make recommendations on how they could better, say they meet the basic compliance with the standard, or they have substantial compliance, this can still make recommendations to the facility for how to improve their investigations, their internal investigations situation there. So I hope that answered that.
Yeah, there was a quick follow-up for that. Regarding that first question, have you seen the DA's office, for instance, offering to assist DOC with evidence collection or investigations as needed?
I haven't personally, well, that's not true. So I can talk specifically about the state that I have done the most work in, which is Texas. They created a special prosecution unit that dealt only with allegations of crimes in correctional facilities. And they had an adult division and a juvenile division. And so those attorneys, those prosecutors inside those offices, acted instead of the local county DA to prosecute those cases. And in some of those situations, they did help with additional evidence collection. I'm sure there might be cases where investigators assigned to the local DA's office may help work a case, and it would depend on jurisdiction and how rural the area is, how many resources they have. We recently did a big audit in the state of Michigan, and the jurisdiction there for law enforcement was the Michigan State Troopers, whereas state troopers in Texas, most of their work has to deal with traffic-related things, and we would call the local sheriff's department or police department for anything that had to do with sexual criminal allegations.
Great. Another question that has come in is, because MOUs don't have the binding effects of, say, contracts, what happens if a facility fails to comply with an MOU provision?
We would recommend that if the facility is not complying with the MOU provision, that the other agency party to the MOU makes, of course, every attempt to sit down with them and see, what's causing that and what can be done to resolve it. And if not, then they would need to rework the MOU. If they had any concerns that the facility's failure was hindering services to the inmates or residents, any potential victims of sexual abuse or assault, then they could report that to the PREA Resource Center. It would be, or to the Department of Justice and the PREA Management Office.
Great. And then the final question that has come in, but please if you do have any additional questions, feel free to type those in. Do caregivers receive PREA educational material if they have a youth detained?
I'm sorry, I missed the very first part of that.
Yeah, so if do caregivers receive PREA educational material if they have a youth detained?
Yes, if a caregiver of a youth who's detained should be receiving some information about the facility that includes references to their website and PREA information. So in many cases, it's acceptable for a facility to do that in a number of different ways, but it should be printed material that they're receiving that has either access to a website with more information or a number they can call if printed materials aren't appropriate for that person for whatever reason, where they can get further information about PREA standards and their child's right to sexual safety in the institution.
Great. So those are all the questions, Teresa, that have come in so far. Like I mentioned, if there are other questions that you all have, please feel free to type those in at this moment. While people are doing that, are there other things that you'd like to share with folks on the webinar?
Well, I would just encourage one of the things that I think is really important in the juvenile system is for people to understand how it works in their state. So if you're an advocate or another staff member who deals with the juvenile system and you haven't had, you're having to now provide these advocacy services, but you haven't had a lot of interaction with it previously, taking those tours and finding out more about the facilities and systems is really helpful and enlightening. You'll find that for the most part, the facilities are much like schools with dormitories and not as intimidating as, say, an adult correctional environment might be.
Great. And so it looks like those are all the questions that that have come in. Would you like to share your contact information or anything that you'd like to share moving forward?
Yes. There we go. We have, of course, the link to the National Center there, the National PREA Resource Center. We have a contact us page if you have any specific questions that come up later. And then that is my personal email address with the PREA Resource Center. And feel free to contact me if there's anything that I can assist you with.
Great, thank you, Teresa, and thank you all for joining us today, for making the time in your, I'm sure, busy schedules. Please do, if any other questions come up, reach out to Teresa, to the PREA Resource Center, reach out to me and I can make that connection as needed. Again, thank you so much, Teresa, for sharing this fabulous information. It's important for us to know and for absolutely taking the time to answer the questions that that came in and that folks had. As far as next steps, look out for the follow-up email that should be emailed here within the next 30 minutes or so. As a reminder, please do fill out the survey for us. It's very helpful in order to continue to make the webinars better for you all. We do have some follow-up webinars or some webinars that are coming up. Our next webinar will be on March 20th, and it'll be about the SAVE program, the payment program for medical and anonymous sexual assault reports. So if that's something that you've been interested in and had some questions about how to access that program, please do join us on March 20th, again from noon to 1 p.m. Someone from the Office for Victims Programs in DCJ will be joining us to do that webinar. And as always, and again, thank you so much for attending, and let us know if there's any ways that, that CCASA can support you.
Thank you for having me.